What if I told you that a court ruling could leave thousands of gun owners scrambling to understand their rights before tomorrow? And while many Australians are focused on this major development, there's another crisis quietly affecting millions of retirees: the future of age pension payments, pension increases, and the financial challenges facing seniors across Australia. In this video, I'll break down exactly what this ruling means, what actions gun owners may need to consider, and why pensioners should be paying close attention to the latest age pension updates that could impact their income and retirement security. Stay with me until the end, because one overlooked detail could affect you or your family sooner than expected. And if you're an Australian senior, retiree, or someone planning for retirement, make sure you subscribe right now. This channel is dedicated to bringing you the latest age pension payment updates, pension changes, retirement news, and financial alerts that matter most to Australians. Something is happening right now at the highest court in the land, and if you own a firearm or carry a concealed weapon, you need to stop whatever you are doing and pay close attention, because the decisions being made in Washington this very term have the potential to change everything you thought you knew about your gun rights, your carry permit, and where you are legally allowed to bring your firearm in the United States of America. This is not a drill. This is not speculation. This is the Supreme Court of the United States actively reshaping the Second Amendment landscape in real time, and most gun owners are completely in the dark about what is coming. Let's go back to 2022 for just a moment, because that is where this story truly begins. In a landmark ruling known as New York State Rifle and Pistol Association versus Bruin, the Supreme Court dropped what can only be described as a constitutional earthquake. In that decision, written by Justice Clarence Thomas, the court held in a 6-3 split that the Second and 14th Amendments protect an individual's right to carry a handgun for self-defense outside the home. Read that again. Outside the home. The court was not just talking about your right to keep a weapon at your bedside table. It was talking about your right to carry one on the street, in your car, into public spaces, as you go about your daily life. And the court went even further, pointing out that 43 states already had what are called shall issue permit laws, meaning if you meet the basic criteria of age, background check, and clean criminal history, the government has to issue you a permit. They don't get to say no just because they feel like it. For millions of gun owners across the country, Bruin felt like vindication. But what no one fully anticipated was the firestorm it would set off in the states that didn't like the ruling one bit. States like Hawaii, California, New York, Maryland, and New Jersey looked at the Bruin decision and decided they were going to fight back by any means available. If the Supreme Court said you could carry a gun outside the home, fine, these states thought. But we'll make sure there is almost nowhere outside the home where you're actually allowed to have it. What followed was a wave of legislation creating massive lists of so-called sensitive places where firearms were suddenly prohibited. Parks, restaurants, shopping centers, parking lots, banks. Almost anywhere that a member of the public might walk into became, under these new laws, a place where your permit was effectively useless. And leading the charge was the state of Hawaii, which in 2023 passed a law so sweeping that gun rights advocates immediately gave it a nickname. They called it the Vampire Rule. And once you understand what it actually does, you'll understand exactly why. Under Hawaii's Act 52, a licensed concealed carry permit holder is prohibited from bringing a firearm onto any private property that is open to the public. And that means restaurants, grocery stores, shopping malls, parking facilities, banks, and countless other everyday locations, unless the property owner has given explicit, affirmative permission for firearms on the premises. Think about what that means in practice. Without a specific green light from every single property owner you encounter in your day, your carry permit becomes essentially worthless the moment you step outside your front door and try to live a normal life. You cannot assume permission. You cannot enter a business without first knowing whether or not the owner has expressly said firearms are welcome. And if you get it wrong, you are a criminal. That is the Vampire Rule in action. You cannot enter without being invited in, and unlike the folkloric vampire of legend, the government does not care whether or not you meant any harm. You are guilty simply for being there. James Wolford, Allison Wolford, and Adam Kasperzicki are 3 Maui residents who found this out the hard way. All 3 held valid, legally issued concealed carry permits in the state of Hawaii. All 3 were carrying legally in the ordinary course of their daily lives, and all 3 were arrested for carrying in locations where they had not obtained explicit permission from the property owner. They were not threatening anyone. They were not acting erratically or dangerously. They were simply exercising what they believed, and what the Supreme Court had already affirmed in Bruin was their constitutional right to self-defense outside the home. They fought back, filing a lawsuit that argued Hawaii's Act 52 violated the Second Amendment under the Bruin standard, which requires that any gun regulation be rooted in the historical tradition of firearm regulations in American history. Their case, joined by the Hawaii Firearms Coalition, eventually became the vehicle that would carry this fundamental question all the way to the United States Supreme Court. That case is called Woolford versus Lopez, and it is one of the most consequential Second Amendment cases the nation's highest court has agreed to hear in years. The Ninth Circuit Court of Appeals, one of the most reliably liberal federal appeals courts in the country, had upheld Hawaii's ban. In their view, the historical record contained enough evidence of restrictions on firearms in crowded public gatherings to justify Hawaii's sweeping modern law. But here is where things get deeply important. Other federal circuit courts, including the Second, Third, Fifth, and Seventh Circuits, had looked at similar private property bans and reached the opposite conclusion, striking them down as unconstitutional under the Bruin framework. This is what lawyers call a circuit split, and it is essentially the Supreme Court's engraved invitation to step in and resolve the conflict. When different federal courts across the country are reaching opposite conclusions about the same constitutional question, the Supreme Court has to act. And on October 3, 2025, it did exactly that, agreeing to take up Woolford versus Lopez for the 2025 to 2026 term. Oral arguments were heard on January 20, 2026, and what happened inside that courtroom sent shockwaves through the legal community and the gun rights world. Chief Justice John Roberts himself grilled Hawaii's attorney Neil Katyal on the logic of the property owner consent provision, pointedly questioning whether the framework raised not just Second Amendment concerns, but even First Amendment issues. The conservative majority, which has shown a consistent willingness to strike down gun restrictions that lack solid historical grounding, visibly challenged the legal foundations of Hawaii's approach. Legal observers who attended the arguments walked away largely convinced of one thing: the court is almost certainly going to rule against Hawaii. The only real question is how broadly, and what that means for the dozens of similar laws across the country. And this is where every gun owner in America needs to lean in, because the implications of a ruling in favor of Woolford are absolutely enormous. If the Supreme Court strikes down Hawaii's default ban framework, it will not just affect the Aloha State. It will serve as a constitutional death sentence for nearly identical laws that were passed in California, New York, New Jersey, and Maryland in the wake of the Bruin decision. Millions of concealed carry permit holders in those states, who have been effectively stripped of any practical ability to carry in public, will see those restrictions crumble. Gun rights organizations, including the Second Amendment Foundation, which is already involved in nearly 60 related cases in federal courts right now, are watching Woolford as the precedent-setting domino that could topple an entire architecture of restrictive post-Bruin state legislation. Alan Gottlieb, the founder of the Second Amendment Foundation, has been blunt about it. The Bruin decision opened the floodgates for challenging gun restrictions, and what comes out of Woolford will determine how wide open those gates actually swing. But Woolford is not the only case that gun owners need to have on their radar. At the same time the court is wrestling with where you can carry your firearm, it is also deciding who gets to own one at all. United States versus Himani is the second major Second Amendment case before the court this term, and it raises a question that affects a staggering number of Americans. The case involves a federal statute that prohibits the possession of firearms by users of illegal drugs, a law that seems straightforward on its face until you start to examine it through the lens of modern marijuana use and the Bruin historical tradition test. Ali Daniel Himani is a Texas man whose home was searched by FBI agents. They found a Glock 9mm pistol, 60 grams of marijuana, and a small amount of cocaine. He was charged under a federal law that makes it a crime for any person who is an unlawful user of, or addicted to, any controlled substance to possess a firearm. The Fifth Circuit Court of Appeals ruled in his favor in early 2025, citing related precedent that found a marijuana-smoking gun owner who was not impaired at the time of possession could not be constitutionally charged under that statute. The federal government took the case to the Supreme Court, which agreed to hear it with oral arguments held on March 2, 2026. The question before the court in Himani is whether the historical tradition of disarming people due to intoxication or drug use is sufficient to justify a permanent, categorical ban on firearm possession for current drug users. This matters deeply to millions of Americans who use marijuana in states where it is now fully legal under state law, but remains federally prohibited. Under the current federal statute, someone who legally purchases cannabis in Colorado and owns a firearm is, technically, a federal felon. The Himani case could either lock that paradox in permanently or begin to unravel it, depending on how the justices apply the Bruin framework to the historical record. And the landscape does not stop there. Even as these two blockbuster cases work toward decisions expected by late June or early July of 2026, dozens of other Second Amendment challenges are percolating through the lower courts, all building toward the Supreme Court. The Felon in Possession statute, the law that bars anyone convicted of a felony from owning a firearm, is under sustained constitutional challenge. Courts across the country are being asked whether someone convicted of a non-violent felony can be permanently stripped of their Second Amendment rights. And in early 2026, the Supreme Court declined to take up that broader question immediately, but left a long list of petitions for further review, signaling that it is watching and waiting for the right case at the right moment. The question of semi-automatic rifles and so-called assault weapon bans is also working its way through the courts. Illinois passed one of the most sweeping such bans in the country, and it is being vigorously challenged. Legal scholars believe the AR-15 question, whether commonly owned semi-automatic rifles can be banned at the state level, is inevitable before the Supreme Court in the coming years, and how the court rules in Woolford and Himani will shape the doctrinal tools it uses to answer that question when it arrives. So what does all of this mean for you, practically, right now, today? If you are a law-abiding gun owner or a concealed carry permit holder, the answer depends significantly on where you live. If you are in a state like Texas, Florida, or most of the South and Midwest, you are largely carrying under shall issue or even constitutional carry frameworks that have already been upheld. But you should be watching what happens in Woolford, because a sweeping ruling in favor of gun owners could further cement your rights and foreclose future legislative attempts to chip away at them. If you are in California, Hawaii, New York, New Jersey, or Maryland, the Woolford ruling could be transformational. The restrictions you have been living under, the lists of prohibited places, the default bans on private property carry, the effective neutering of your permit in daily public life, could be struck down. But do not stop carrying your permit, and do not act as though the ruling has already happened. Until the Supreme Court issues its official opinion, the laws in those states remain in effect, and violating them carries real criminal consequences. Do not get arrested while waiting for a ruling to save you. Check your state laws right now. Understand exactly where your permit currently allows you to carry and where it does not. If you live in a state affected by post-Bruin legislation, consider following the case updates closely through sources like SCOTUS blog, the Second Amendment Foundation, and your state's firearms law attorneys. If you use marijuana in a state where it is legal, understand the federal conflict that Himani is trying to resolve and the very real legal risk you currently carry by possessing both cannabis and a firearm under federal law. Know that the government is not yet bound by what most observers expect the court to decide. Federal law is still federal law until a ruling says otherwise. And beyond the legal specifics, there is something larger happening here that every American who cares about constitutional rights should understand. The Supreme Court is in the middle of a multi-year project of rebuilding Second Amendment jurisprudence from the ground up, using the Bruin standard as its foundational tool. The old regime, in which judges applied a balancing test that weighed government interests against individual rights and routinely upheld gun restrictions, is gone. In its place is a new historical tradition framework that demands the government find genuine historical analogs before it can restrict your right to keep and bear arms. That framework has proven enormously powerful for gun rights advocates, and the cases moving through the courts right now are testing just how far it reaches. The decisions expected by June and July of 2026 will not be the end of this story. They will be the next major chapter in what is clearly a generational legal battle over the scope and meaning of the Second Amendment in modern America. Stay informed, stay legally compliant, and stay ready, because the law governing your rights as a gun owner in this country is changing faster than at any point in recent memory, and the gun owner who understands what is happening is the one who can protect both their rights and themselves.